you ever wondered if you can withdraw money from a deceased person's bank account? This is a crucial question that many people face, and understanding the legalities can significantly impact how you manage a loved one's estate. In this video, we'll delve into whether you can legally access funds from a deceased person's bank account and the steps you need to follow. You can withdraw money from a deceased person's bank account if you are a joint owner of the account. Joint accounts with rights of survivorship allow the surviving account holders immediate access to the funds upon the other owner's death. However, if you are not a joint owner, gaining access to the deceased bank account requires presenting legal documents to the bank. These documents can include a court order or letters testamentary which authorize you to manage the deceased estate. Unauthorized withdrawal from a deceased person's account before legal authorization can be considered illegal. This act could be viewed as theft or fraud, leading to serious legal repercussions. Dealing with the aftermath of a loved one's passing can be daunting, especially when it comes to handling their estate. The legal framework governing estate settlement includes navigating through probate and resolving any estate litigation. An executor appointed by the will or the court is responsible for managing the deceased estate through probate. Probate is a court-supervised process for authenticating the will, paying outstanding debts, and distributing the remaining assets to the rightful heirs. One of the first tasks of an executor is to locate and compile an inventory of the deceased assets, including all bank accounts. Your attempt at withdrawing money from a deceased bank account may compel you to traverse the complex route of trust and estate litigation. Both known and unforced disputes regarding access to the deceased bank account may emerge, often contributing to family feuds. During these times, engaging in litigation becomes a necessity rather than a choice. The litigation process begins with an initiating the process and ends with the enforcement of the judgment. In between lie stages such as pleadings, discovery, trial, and perhaps appeal, all extending the timeline for accessing funds. We understand that the probate process can be arduously protracted, but it's an indispensable aspect of legally withdrawing money from deceased bank accounts. The role of an executor cannot be understated in the course of estate administration. They are entrusted with the fiduciary duty to manage the deceased assets, including closing bank accounts and distributing funds to the beneficiaries. Let's break it down step by step. First, you need to find and understand the deceased last will and testament. Then you'll kick off the probate process in the right court. After that, you need to take a good look at all deceased assets and liabilities. Make sure to evaluate and pay off any debts. Finally, you will distribute what's left according to the will's instruction, and don't forget, joint accounts can be a game changer. They usually transfer directly to the surviving account holder, skipping probate altogether, which can really shake up how the funds get distributed. Life insurance policies and retirement accounts typically follow a transfer on death arrangement. Their relation to probating the deceased bank accounts is negligible. Probate laws can vary significantly by state, impacting how you may legally withdraw money from a deceased person's bank account. Compliance is key for a smooth transition of assets. Adhering to legal requirements when dealing with the estate of a loved one is critical. Failure to do so can result in serious implications, including legal penalties and disputes among heirs. Unauthorized access or withdrawal from a deceased bank account can lead to serious legal repercussions. It could be considered theft or fraud and result in criminal charges, fines, or civil litigations. Estate litigation may arise when there are disputes over the deceased will or claims against the estate. This might delay the process of accessing the deceased bank funds. In most cases, joint accounts bypass the probate process, and the surviving account holder can access the funds immediately upon the death of the other account holder. Handling the bank accounts of a deceased loved ones depend on the type of account, ownership structure, and whether there's a will or named beneficiaries. Joint accounts with rights of survivorship and accounts with payable on death and transfer on death designations bypass the probate process, transferring directly to named beneficiaries. on other bank accounts may be subject to probate, where debts are settled and then assets are distributed accordingly to the deceased will or state laws. Whether you are the executor of an estate, a beneficiary, or a loved one, it's common to wonder what happens to a bank account when someone dies. The answer depends on several factors, including the type of account, its ownership structure, whether the deceased left a will, or whether the account has named beneficiaries. After receiving notification from an account holder's death, a bank will take prompt steps to secure the assets. For an account owned by a single individual, this typically includes reviewing the account to confirm its ownership status and determining whether it has a beneficiary designation. The bank will request documentation such as a certified copy of the death certificate and legal documents indicating who has the authority to make decisions regarding the deceased assets. That's all for today. Thank you for watching. Please share and subscribe to our channel for more financial insights.